Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. You know, I had two pro se's to contact me this week regarding their complaint. In one instance, the court returned the complaint to the pro se, asking the pro se to set forth his allegations and causes of action more clearly where the court could understand. And likewise, with the other person, they needed the same kind of help. And I'm glad to help. So, we're going to talk about avoid filing a shotgun complaint. Because I can assure you, the defendant will file a motion to dismiss for failure to state a claim upon which relief to be granted. And the court sua sponte or on its own could also challenge the complaint. And I've seen it over and over again where the court challenged the complaint. So we're going to talk about organizing your facts and causes of action in a way that the defendant is put on notice that they've been sued, and where you have multiple defendants, where each defendant knows that he's been sued and specifically what he has been sued for. So let's get started. The court really, it views a shotgun complaint as a throw against the wall and see what sticks approach. Organization is key. The complaint allegations and the causes of action should be stated succinctly, and they should be separately organized and compartmentalized in a manner that the court understands what the plaintiff is alleging, what allegations are being made, and against whom, and the law the plaintiff is relying on to support her claims. That's a lot, but it's necessary and it can be done. The complaint must comply with Federal Rules of Civil Procedure. Federal Rules of Civil Procedure 8A2 requires a short and plain statement of the claim showing that the pleader is entitled to relief. And I am going to show you what that looks like. Federal Rules of Civil Procedure 8B1A, if you are responding to a complaint, state in short and plain terms its defenses to each claim that is asserted. Federal Rules of Civil Procedure 10B, to promote clarity, a party must state its claims or defenses in numbered paragraphs. And I'm going to show you that, each limited as far as practicable to a single set of circumstances. So let's look at the defendants. Defendant one, who happen to be deputies. Deputy one is alleged to have stopped plaintiff's vehicle without probable cause, searched his person without probable cause, and without his consent, and that he unlawfully detained him. Deputy 2, Defendant 2 is alleged to have searched plaintiff's vehicle without his consent and without probable cause, and that he unlawfully detained him. Deputy 3 is alleged to have used excessive force upon plaintiff by beating him in the patrol car as he was being transported to the jail, and that he unlawfully detained him. When we say him, of course, we're referring to plaintiff. So what we're going to do is a mock complaint against the three defendants. And I encourage you to use this pre-prepared form. It will really make your litigation easier, okay? All right. So the caption, complete the caption, and everything is pretty much self-explanatory. But let's just go through it quickly. So you have your caption, the plaintiff information, B, the defendant's information. And in this case, this will work because the plaintiff is suing multiple defendants. 2, the basis for the jurisdiction, whether it's federal question or diversity of citizenship. A, if the basis for jurisdiction is a federal question, you want to list the specific federal statute or treaty, any provisions of the United States Constitution that are at issue. For example, in this case, 42 U.S.C. 1983 is at issue. The 4th Amendment, 14th Amendment are issues. B, if the basis for jurisdiction is diversity of citizenship, you want to complete that information for the plaintiff, for the defendant or defendants. And 3, this is the part where we want to hone in on. You want to attach your statement of claim. And I'm going to go over a mock statement of claim specifically for this case that I put together. So you want to put something like see Exhibit A. And then we're going to have Exhibit A attached separate from this. Then, of course, 4, you want to state your relief. 5, you want to sign. Okay? All right. So let's do this. Okay, so pro se. This mock complaint represents organization. It represents putting the defendant on notice that they've been sued, what they've been sued for. You want to compartmentalize your complaint so that the judge can follow your allegations, understand what the causes of actions are, and understand that you have made them clear enough for the judge to make a decision, okay? So I want to go through each allegation. Now, your Exhibit A statement of claim, factual allegations. 1, on or about January 1st, 2024, Defendant 1 stopped plaintiff's vehicle as he was driving down Interstate 5. Remember, you want relevant and material facts. 2, at the time of the stop, plaintiff was driving 60 miles per hour. 3, the speed limit on Interstate 5 was 70 miles per hour. 4, Defendant 1 and 3 walked to plaintiff's car. 5, Defendant 3 stood on the passenger side of plaintiff's vehicle as Defendant 1 requested his driver's license. 6, Defendant 1 and 3 failed to state why they stopped plaintiff's vehicle other than he looked suspicious. 7, Defendant 1 ordered plaintiff out of his car, to which plaintiff complied. 8, without any warning or plaintiff's consent, Defendant 1 commenced searching plaintiff's person. 9, Defendant 2 arrived at the site approximately 30 minutes after Defendant 1 searched plaintiff. Now, you see what's going on here? You have so far, you have these 3 officers involved in these violations. And so Defendant 2 arrives at the scene. Defendant 1 and 3, they're already there. And number 10, without any explanation, warning, and without plaintiff's consent, Defendant 2 searched plaintiff's vehicle. So you have different actions by different defendants. So we need to make sure that they are compartmentalized where each defendant understands that he's being sued and what he's being sued for. And the court needs to understand that too, okay? 11, defendants 1, 2, and 3 detained plaintiff at the scene for over 6 hours. 12, finally, defendants 1 and 3 transported plaintiff to the jail. 13, defendant 3 sat in the back seat of the patrol car, of course, and without provocation started beating plaintiff on the head. Now, defendant 3 did this, defendant 1 and 2 did not. So we want to make sure that defendant understands that this particular cause of action is asserted against him, okay? So let's get into the claims. Now, often the plaintiff would assert federal claims and state claims. Remember, we talked about pendant jurisdiction in a video I did a couple of weeks ago, okay? So the first cause of action is the Fourth Amendment violation, unlawful search against defendants 1 and 2, right? Because defendant 3, one could argue, was not involved in the unlawful search, right? 14, plaintiff hereby incorporates the preceding paragraphs as if related herein, specifically paragraphs 7 through 10, as it pertains to defendants 1 and 2. And if you go back and look at 7 through 10, that's where the search commences, right? Okay. 15, defendant 1 violated plaintiff's right to be free of a search and seizure when he searched plaintiff's person without a warrant and probable cause. 16, defendant 2 violated plaintiff's right to be free of a search and seizure when he searched plaintiff's vehicle without plaintiff's consent and because he lacked probable cause to believe plaintiff was committing a crime or was in the commission of a crime. And you see how it is stating the elements of the violation for unlawful search. You see that? Second cause of action, Fourth and 14th Amendment, unlawful detention against defendants 1, 2, and 3. 17, plaintiff hereby incorporates the preceding paragraphs as if restated herein, because all of these paragraphs set forth the Fourth and 14th Amendment violations. 18, each defendant violated plaintiff's right not to be detained without a warrant and probable cause. That's Fourth Amendment language, right? And they violated plaintiff's liberty interest right to be free from an unlawful detention. That's 14th Amendment language. Third cause of action, Fourth Amendment violation, excessive force against defendant 3, right? Because 1 and 2 were not engaged in excessive force. 19, plaintiff hereby incorporates the preceding paragraphs as if restated herein, specifically paragraph 13 as it pertains to defendant 3. Let's go back up to paragraph 13. Here we go. Defendant 3 sat in the back seat and without provocation started beating plaintiff on the head. Okay? 20, defendant 3 violated plaintiff's right to be free of an unlawful seizure with a warrant and probable cause, and he unreasonably and without justification violated plaintiff's right to be free of excessive force. Okay? You getting it? Compartmentalizing these, okay? Now, I'm throwing in a state claim here. In the first cause of action, assault and battery. Against who? Defendant 3. Okay? 21. Plaintiff hereby incorporates the preceding paragraphs as if restated herein, specifically paragraph 13, as it pertains to defendant 3. You see where you are honing in on the allegation that helps you to support this argument. Of course, assault and battery is going to differ from state to state. So you'd want to use the language that is applicable to the jurisdiction in which the lawsuit is filed. But here is a general definition. 22. Defendant 3, by his actions, cause plaintiff to be placed in apprehension that plaintiff would be imminently and physically harmed, and plaintiff was harmed by defendant's violent beating. Okay? And so that would be it, because remember, you signed in the pre-prepared complaint. Remember, this is the exhibit, right, to section 3 of the complaint. So all you need to do is attach this document to the prepared complaint. Got it? I hope this has been helpful to you. I'm Advocate Lucinda, and we'll see you next time. Take care.